Bob and Joe, Robert Robes, graduated class of 1997.
That's right.
Joe Landolfi graduated the class of 1997. We have somebody else here who graduated in the class of 1990. Oh, Stu Kasner. Stu Kasner was 1997. And I'm trying to think of who else. I think they may have already left. Anyways, this is our federal, state, and gift tax panel, and you're going to enjoy this. So I'll introduce them in alphabetical order based on their last name. Joseph M. Landolfi Jr. has been practicing law in South Florida for over 20 years, representing the unique needs of high net worth clients and businesses. Mr. Landolfi earned his BS in accountancy from Villanova University and his MS in taxation from Farley High Dickinson University. He earned his JD from St. Thomas University School of Law and went on to earn his LLM in taxation from Boston University School of Law. Mr. Landolfi ran his own boutique practice for several years before becoming a partner at Buckingham, Doolittle, and Burroughs, a multi-state firm based in Ohio. He then became a partner at Ackerman LLP, a firm ranked among the top 100 U.S. law firms by the American Lawyer. Presently, he is a partner in Shapiro, Blasi, and Wasserman and Herman, PA, one of Boca Raton's largest law firms, where he heads their estate planning practice division. Joe was my student and graduated here in 1967. Robert Robes is a senior vice president, Wells Fargo Private Bank. Robert is a senior wealth planner located in the Boca office of Wells Fargo Private Bank. Mr. Robes works with clients to help develop and implement custom wealth planning structures based on thorough understanding of their personal planning and transfer goals and objectives, taking into account a client's individual values and unique family dynamics. Prior to joining Wells Fargo, Mr. Robes was a shareholder in the Tax, Trust, and Estate Department at Greenberg Trauer, PA, where he was an attorney for almost 16 years with a focus on private wealth management, personal business structuring, and estate planning for ultra-high net worth individuals, families, and entrepreneurs. Mr. Robes is also an adjunct professor here at St. Thomas University School of Law, where he teaches a course in estate planning. Mr. Robes earned his Master's of Law degree in taxation from New York University School of Law, his Juris Doctorate degree from St. Thomas University School of Law, and his Bachelor of Arts degree in Political Science from Florida Atlantic University. He is a member of the Florida Bar, currently not practicing. As an active member of the community, Mr. Robes currently serves as Director of Florida Atlantic University Foundation, the Vice Chair and Trustee of the YMCA of South Palm Beach County, and Secretary and Director of the Florence Fuller Child Development Centers, and volunteers for the Colorectal Cancer Alliance. He lives in Coral Springs, Florida, with his wife, Emily, and has 2 children, Mr. Robes and Mr. Landolfi.
All right. Thank you. All right, good afternoon, everybody. We're going to try to get you out of here on time, so we have 15 minutes. So, all right, actually, we're not going to do that, but we're mindful of the time, and so we'll talk a little faster. Now I got to see if I can get this to work. All right, let's see. There we go. Oh. Got it. All right. So, first is an update regarding the changes to the federal estate, gift, and generation skipping transfer tax provisions made by the Tax Cuts and Jobs Act. As Professor Wolf stated earlier, the lifetime exemption was doubled under the Act, and it went from $5 million to $10 million indexed for inflation. And so what you see in the statute is that it actually went from 5 to 10, but in 2019 that exemption is $11,400,000. It does sunset as of January 1, 2026, at which time the exemption will revert back to $5 million indexed for inflation, but the number that's been used to calculate the increase changed, and so the increases actually will be less than they had been prior. This enhanced exemption amount is a use it or lose it proposition, which we'll talk about in more detail later. The statute gave Treasury the authority to promulgate regulations to interpret any differences in exemption amounts for gift as opposed to death. And the reason that's important is because before a regulation was issued in November of 2018, there was concern that there would be a disconnect between an individual who had made a gift utilizing the exemption, and then if there was a rollback, that the IRS would have an opportunity to claw back and make that what was a non-taxable gift at the time it was made, in fact, taxable. The regulation provided some comfort and stated that there will not be a clawback, and that the law in effect at the time that the gift or the bequest was made will continue to apply even in the result of a sunset.
They're going to do the formula clause on that to allow for any type of credit to be instilled. All right, slide 2, just making sure. As Bob mentioned, the tax rate remains, the state tax exemption rate remains at 40%, and that's been since ATRA 2012. Just some interesting numbers. For 2018, it was anticipated, or is anticipated because we haven't had the actual numbers yet, about 4,000 estate tax returns would be filed for decedents, of which approximately 1,700 to 1,800 returns would be taxable. So we're talking about less than 0.1% of the estimated 2.7 million people that were estimated to pass in 2018 would be responsible for filing an estate tax return and 1,700 paying the tax. They estimate the tax to be about $14.9 billion as a result of the estate tax exemption amount and the liability. So we're talking about a very small percent of individuals passing away subject to an estate tax liability and subject to a tax. This is going to be key part of our conversation as we go through this, understanding that we're talking about a small percentage, but there's non-tax reasons. Obviously, the date of death value becomes the new cost basis versus the transfer basis when gifts made during lifetime. There's no limit on the amount of the step-up in basis with regard to the marital portion, marital trust, the credit shelter. The deceased spouse unused exemption, the portability, remains intact. Although, again, you must file a simplified, and I'll put that in quotes, Form 706 to utilize the DSUI amount. They call it a simplified version, but you still have to go through all of the schedules, exhibits, accountings, appraisals in order to make that determination appropriate. Just be aware that even though the DSUI amounts are being utilized and you elect that portability, the IRS has the ability, upon the death of the surviving spouse, using the DSUI amount, to go back to the first deceased spouse's estate and reopen it. There is no statute of limitations period expiring on that amount. So when you're talking with clients and the DSUI amount is available and being utilized, you need to alert them that the IRS can go back, reevaluate the 706 of the first spouse to die, open that up for pool purposes. As we said, the GST transfer tax exemption remains the same at 11.4, but is not subject to portability. It is a use it or lose it scenario, and we'll be discussing planning opportunities with that. The annual gift tax exclusion remains at $15,000, with gift splitting equal to $30,000. No changes there, no surprises there. When there is an election to gift split, it is a uniform election for that year. There is not the pick and choose amount or topic. The next slide, we're going to talk about federal, state, and gift tax rates. Again, stepped up basis at time of death, unlimited marital deduction. With regard to surviving spouses, as long as they're U.S. citizens, there are limited marital deduction you can have. With regard to limitations on marital deductions for gifts to spouses who are not U.S. citizens, during lifetime, that amount is increased to $155,000. So lifetime transfers to non-citizen spouses, limited to that. There's not an unlimited lifetime marital deduction for that. And no marital deduction for transfers to non-citizens at death unless you create what's called a qualified domestic trust inside your documents. Some planning opportunities with QDOTs. You should provide in your estate planning documents provisions that allow for the surviving spouse to gain citizenship with alternate provisions so that the U.S. citizenship can instill a greater flexibility. But that, again, needs to be done within the 9 months since date of death of the first spouse to die. The surviving spouse has time if they were in the application process. So you say, if the spouse was a U.S. citizen, here's the provisions that apply. If the spouse was not a U.S. citizen, then the QDOT is instilled. So you allow flexibility. And you'll hear that word a lot today regarding flexibility during our presentation because of the uncertainties that we'll talk about. If a non-citizen dies, their exemption is not 11.4, it's $60,000. With regard to non-tax motivated reasons for estate planning, they existed prior to this act, they exist today. Again, we're talking 0.1% regarding the estate tax liability. For these reasons, non-tax liabilities, and for some of our students that are in here, this is ad nauseum to them, but you can distribute assets in accordance with your intentions. You avoid probate in Florida, which is a very long, drawn-out, complicated process. You have the ability to appoint your fiduciaries, the people that you trust. You have the ability to appoint guardians of your minor children. You have the ability to preserve assets, protect assets, not only for spouses, but for descendants, again, regardless of the value of your estate, whether it's taxable or not. You have the ability to provide for your special needs dependents, for your special needs descendants. It used to be taboo. It used to be, I cannot provide for them. I shouldn't provide for them. People were uneducated in allowing special needs children the opportunity to receive benefits through special needs trusts. So you have the ability and continued ability to maintain for them. You have the ability in an estate plan, regardless of the tax, to provide for same-sex couples, same-sex marriages. You have the ability for succession planning. What happens to the business? What happens to heirs, descendants? Who is to take? How much? When? You obviously have your philanthropic planning, and we'll talk about charitable planning soon. And then obviously in Florida, the privacy issues. Everyone knows that when a will is filed with the court, it is public record. Anyone can walk in to a courthouse and gain a copy of someone's will. Such is not the case with a revocable trust in Florida. It is private. So you discuss with clients, regardless of their tax exposure, what their concerns are. And there are many more non-tax reasons, but those are the heightened ones that we typically talk about when we sit down with clients and we go through their estate plan as to why they should implement a plan regardless of their overall gross estate value or regardless of their tax liability.
Okay, so Joe just went through things that were not changed as a result of the Tax Cuts and Jobs Act. Nonetheless, with the increased exemption and other things that occurred, there has been an impact on existing estate plans. So people who put their plans in place prior to the end of 2017. And so as he stated, the Act substantially reduced the impact that transfer taxes would have on an estate plan. He said that there was 4,000 estate tax returns filed, only about anticipated for 2018. Only about 1,700 will have an estate tax due. When we talk about how small a percentage it is, it's actually less than 0.1% of all decedents will file a tax return for which a tax will be due. So we're really talking about a small percentage of the population under current law. And again, it's important to focus on those non-tax items, right? I'm sure anybody that practices in estate planning has come across a situation where somebody says, I don't know why anybody's hassling me about doing an estate plan. I'm not going to pay any taxes. And there's just so many non-tax reasons, and it's important to drive that home in dealing with your clients. You heard Professor Wolf say during his panel that the passage of this act was outside the normal channels in Washington. As a result, there is really a focus amongst commentators and practitioners to utilize this enhanced exemption prior to the end of 2020. And that's under the current political climate. And the reason for that is that should the White House change parties, it is very likely, in fact, I think it is more than very likely, that many of these tax enhancements, or we'll use tax cuts since that's what's in the title, will be rolled back. And one that is sure to happen quickly is with respect to the estate tax exemption. And so many of us who work with high net worth families are advising them, you need to use this or you run the risk of losing it. And if you wait too long, that there's going to be an issue. The problem, though, is that what causes clients to not want to move forward is that they don't want to part with their assets, right? You know, I don't want to give up the control. I don't want to give up the access. And so we're going to talk about later how that's really not the case, how there are planning opportunities available that will allow the utilization of the exemption while still providing access to the assets. Something that also needs to be considered as you're talking about the impact of these plans is the effect that they have on formula clauses. Okay? And Joe, you want to talk about that a little bit?
Sure. Typical estate plans, back when the estate tax exemption was $1 million, probably prior to some of you out here, basically one was $600,000, the formula clause that were utilized were, in general, let me fund the credit shelter trust, the family trust, with an amount equal to my full life exemption so that those assets pass estate tax free. Maximize the credit shelter trust, and any spillover, any excess funds would go into the marital portion. That might have been fine for individuals that did estate plans back then, but now we're talking about, instead of a $600,000 exemption, $1 million exemption, even a $3.5 million exemption in 2009, we're now at $11.4 million. Think of the impact that can have on a family, a husband and wife, where their assets are somewhat significant, but their plan was provide for expenses passing and provide for assets passing estate tax free, the balance over. That sounds fine. But now let's inject a second marriage. Now let's inject prenups, postnups, children from a prior marriage, where in the past it was, I have $2 million, I'm going to fund my family trust with the estate tax exemption of $1 million, knowing that the spouse will have another $1 million in a marital portion for him or for her. This family shelter trust could have been set up and established just for the descendants, the children from a prior marriage. The surviving spouse set up for her, solely for her because of the marital deduction. If the assets then are increased, where the exemption is now $11 million, without reviewing those proper formulas and going through with the client, you now have inadvertently omitted a surviving spouse from receiving benefits if the scenario I just talked about applied. The $2 million that was supposed to be split all goes to the credit shelter trust, omitting the surviving spouse. There's other things that can occur with elective share and so on, but the formula clause doesn't necessarily work effectively given the exemption that we are at today. So we have to review all of these formula clauses, and we'll address what to do later on in our presentation on what are opportunities, what are available, so that the flexibility is there at the time of death to provide for this. So obviously, meeting with clients, you have to address, is this a first marriage, long-term marriage? Does the provision you have address and adequately complement your intent, your goals, your objectives? Looking at second marriages, descendants from prior, prenups and postnups. Those are the things that I see regularly, because individuals stating, I'm not having a taxable estate, I don't need to revise my estate plan, these provisions are key in talking with him or them in deciding what formula clause or what other opportunities there are out there. Bob, you want to address?
Yeah,
Sarah?
and something else to consider is revisiting the charitable provisions that are in documents. You know, many clients engage in tax-motivated philanthropy. And so as a result of the enhanced exemption, there may be, that may eliminate some of the incentive that a client has had in making a charitable gift. The other issue is when you think about the standard deduction and how that doubled, that eliminated some income tax motivation to making charitable gifts. So revisiting those provisions is important. Interestingly, however, there's been a couple of surveys that I came across since the passage of the Tax Cuts and Jobs Act, which stated that actually planned giving has increased as a result of the tax cut. So people who otherwise were keeping money available to pay taxes are now taking a portion of those funds and using them to achieve their philanthropic goals. So make sure that when you're talking with clients, revisit their charitable inclinations and see if they want to make some changes there as well.
Okay. Consistent with the planning considerations, we want to talk about clients' net worth, their projected future growth. No one has a crystal ball. No one knows when they're going to pass away. No one knows what assets they are going to own at the time they pass away. And no one has a certainty on what the estate tax laws are going to be. So when you meet with clients and when you address with them their estate plan, obviously their current net worth easily ascertainable. You work with individuals like Bob Robes and their financial structure, work with advisors to help you meet with the client, obtain their information, and move forward on that.
Yeah, to that point, Joe, you know, when we're talking about projecting future wealth, there is a lot of uncertainty out there. We have this law that currently sunsets on December 31st of 2025, right? And so we do want to consider different models, however, right? So what if the law does revert back in 2021, at the end of 2021, rather than the end of 2025? What if it ends up becoming permanent? And you sit down with clients and you model it out so that your client can make a well-educated decision. Mm-hmm. You know, granted, much of what we do in planning is modifiable, right? If we're talking about revocable trusts and that sort of planning. But when we get into irrevocable planning, where we're talking about utilizing the exemption, it's sitting down with clients and just kind of modeling it out, what it's going to look like under different scenarios. That's just something that I believe is just prudent in advising your clients.
Exactly. Bob and I were teaching 2010 class, and that was the year that there was the estate tax disappeared. So in planning for it, we had to talk about if 2009 extends, if 2010 applies, or December 27th, when it all went to 5.12 million, the planning opportunities there were what-if scenarios. That's what we're talking about here. You're not going to make the decision for the client, but you want to inform the client of opportunities, potential issues, so that the client can make a decision on the course of action they feel comfortable with. So you calculate projected growth. You work with them on their expenses. You work with them to determine, is their estate growing? Is their estate being depleted? You analyze the federal transfer rules, the gift tax, the estate tax, the generation skipping tax, what the potential for it is there with their overall estate tax liability and their overall gross estate. You consider spending habits. We don't have time to go into numerous stories, but you will have a lot of eventful moments with clients thinking that they're saving money and they're really not. You project their budgetary concerns. So that's part of the current wealth and projected future growth, analyzing that and then applying it to what the law may be at the time of their projected life expectancy. Balancing spouses' estates where appropriate. Now, this obviously can be very sensitive with regard to the clients coming into your office. If it is a first marriage for 45 years, children of both, and they're sitting there, and for their whole entire marriage, they have had assets jointly titled. Sometimes it's a bit difficult to explain separating accounts, separating funds, so that we can, for lack of a better expression, equalize spouse one and spouse two's individual assets to take use of certain exemptions. That can be a touchy issue, but you need to address it with them. In addition, assuming that were the case, what if this was a second marriage? What if there were children from a prior marriage of spouse one and children from a prior marriage of spouse two? You have to be considerate of the clients that you're meeting with, but equalizing the estate is a planning opportunity to allow for the changes that may occur and counter those changes that would otherwise detrimentally affect your estate plan. We do have the fallback provision of the portability, the DSUI, the portability amount. But again, the purpose, the initial purpose of the portability, the spousal portability, was to allow individuals that did not plan or could not plan the ability to utilize the first spouse's unused exemption. It was almost like, oops, I made a mistake, I didn't plan for it, Congress coming in and Treasury coming in and saying, okay, fine, we'll allow you the opportunity to utilize what you otherwise would not have been able to utilize for lack of planning. We'll talk about portability coming up, but again, that was the original purpose of it. Bob and I both agree it is not an effective, ironclad, 100% planning opportunity. It works in some, but not in all cases.
And let me just add on that. You know, when we're thinking about whether it's appropriate to balance estates, right? One of the main reasons that you want to make sure you balance an estate is to not lose the GST exemption of one of the spouses, right? And so, again, because the GST exemption is not ported, only the estate tax exemption is ported. And so keep that in mind, as well as, again, and I'll keep coming back to this, the fact that this tax law the current tax law has an end date, right? And so if you look under current law, all right, I have a client that's worth $12 million. There's about $600,000 of exemption that we may leave on the table if all $12 million is with one spouse. Really, that's not significant. However, if the law does roll back and now you have $5 million available to each, you're not going to want to lose the other spouse's GST exemption as part of your plan. So the way that I view planning now is I actually still focus as if this exemption isn't around, because to me it's a more prudent way to plan for your clients in the event that the tax law changes. You've prepared your clients for that. Now, there's other risks that come along with transferring assets to a spouse. Joe mentioned, the 45-year marriage where there's kids and everybody's happy. As we all know, that is a minority of situations that we deal with, right? And so we're going to talk about ways that you can equalize the estates without putting the legal ownership of the assets into the hands of the other spouse. So we'll get to that in a little bit.
We're going to get to one of them right now.
Oh, go for it.
We'll talk about the lifetime Q-tip trust. There's hesitation in giving one spouse assets for his or her availability to devise during death. A way around that to curb that other spouse's angst is to create a lifetime Q-tip trust. And a lifetime Q-tip trust, we're using that to equalize or balance out the estates by transferring assets from one spouse to a trust for the benefit of the other spouse. Because it's a Q-tip, there are provisions identical during death in this lifetime Q-tip trust that allow the first spouse to allocate at death where those assets go, to distribute it to prior children, to distribute it to a prior ex-spouse due to alimony, whatever the case may be. So this is a way, instead of giving unfettered ownership, unfettered control to a spouse that really doesn't want to, but to provide for a lifetime Q-tip trust to such spouse while retaining those strings and maintaining that control and ownership. The reason you would do this is, as Bob mentioned, GST is not portable. One spouse cannot utilize the unused exemption. But with the lifetime Q-tip trust, upon that surviving spouse's passing, that spouse's GST is utilized. So there's a mechanism there to do and control and then bring it back into the plan that was wanted by the original spouse. Any questions on that, or do you want to move on to the next one? Utilize expanded 529 plan benefits.
Actually, Joe, excuse me.
Okay.
Kayla, you have the microphone? All right, so if anybody has questions, feel free to ask, okay? Sorry, we didn't mention that earlier.
Okay. 529 plans. 529 plans
Actually, go back to the, so we skipped one. So to allocate the increased GST exemption to GST non-exempt trusts.
Okay.
So the issue there is there has been, you know, if you think about prior planning, there may have been plans that were put in place where there was there were greater contributions made to a trust than there was GST exemption allocated to that trust. This now provides a second bite of the apple where this enhanced GST exemption amount now can be used to go back and be allocated to the non-GST portion of a trust. You don't get to go back to the day that the trust was formed and let's say that it was seated with $3 million when the exemption was 2, and so you had 2/3 exempt and 1/3 non-exempt. You don't get to just put $1 million. If it's doubled in value, then you got to put $2 million of GST exemption to it. But it does provide an opportunity to go back and correct, or maybe not necessarily correct, but at least utilize this enhanced allocation, this enhanced exemption, if there aren't if you have a grantor that doesn't have additional assets to do further planning, they can correct some prior planning.
And that allocation of GST exemption to a trust that was created prior is all done by filing a 709 and allocating the unused GST exemption to that particular trust at the then current value of the non-GST exempt assets. It's a way to utilize it without having to make an additional contribution and utilize those additional exemption amounts. 529 plans, they're the same except that they've expanded 529 plans to allow for kindergarten through 12th grade distributions, but that is limited to $10,000. It used to just be for higher education. Now they've expanded that to allow for additional distributions. Modify prior planning. Bob, you want to address some of that, or you want me to hit it?
So, you know, very often you've had clients where planning has been put in place. And so, for example, it's been an installment sale to a grantor trust where the grantor is taken back in note, right? So there's an opportunity now where that note could be forgiven. And as a result, it's deemed to be an additional gift back to the trust, okay? And there would need to be GST exemption allocated to that gift, but there is a way to utilize the exemption without having to make an additional outlay of assets other than the installment note that was taken back. So looking at prior planning and seeing if there's a way to utilize this increased exemption amount there. In addition, looking at the substitution power, now this isn't necessarily affected by the Act, but when you go back and you look at a plan, you might as well look at other aspects of the plan. And so many grantor trusts have a power to substitute assets that allows somebody who has been named, this is a fancy term called the substitutor, to actually swap assets of identical value with the grantor, and it's a great way to take low basis assets that are in the trust, swap them for higher basis assets of identical value that are in the hands of the grantor, and then putting those low basis assets back into the hands of the grantor so that upon the grantor's death, there's that step up in basis. So I've talked to a number of clients about this. There are those who are all for it, and then there are those that view the assets in the trust as things that better not be sold, and they don't want to hear about the low basis. And in fact, by keeping it a low basis, it may force the kids to think about not selling that property that mom and dad don't want sold. So, but it's something to think about, is just looking back at these grantor trusts that are in place and seeing if there's some income tax planning that can be done with these low basis assets that are in trust. Okay, so I mentioned a gift, forgiving an installment sale as a planning opportunity, forgiving the note that was the result of an installment sale as a planning opportunity. You know, there's, in addition to sales, sometimes there's just loans, right? There was a very common planning technique. It's been actually common for a while now because we're in this prolonged low interest rate environment where a senior family member, so mom would loan, let's say, $5 million to one of the kids, take back a 9-year note, okay? Hypothetically, the note bears interest at 3%, which is the midterm AFR, and child takes that $5 million and invests it. Child gets, let's say, 8%. You know, we've had a pretty good run in the stock market. Let's say they get 8% a year. At the end of the term, the child repays the $5 million, but has enjoyed the benefit of that arbitrage during the 9-year period. Very common estate planning technique in this interest rate environment. Mom could forgive the note now and take advantage of the increased exemption. And rather than having the child pay the money back, here it's yours. So that's something to consider when you're doing this. Right now, of course, it's a taxable gift, but with the increased exemption, in all likelihood, it's covered. So something to consider there. Also, in discussing gifts, consider utilizing the high basis assets for gifting rather than low basis assets. It's the same concept as with the substitution power, right? There's a step up in basis on assets that are held by a decedent at death. So the lower the basis, the greater the benefit of the step up. So in making gifts to junior family members, consider using higher basis assets rather than low basis. In addition, there may have been a gift made to one child or to a grandchild that wasn't made to another. With increased exemption opportunities, you could equalize those gifts without having to pay gift tax on any of those transfers. So going back, looking at the prior gift history, and then making changes there. Now, I do want to caveat one thing. When we're talking about making gifts of higher basis assets, I'm really talking about gifts to like an individual. If you're making a gift to charity, you want to use low basis ones, okay? So if it's an intra-family gift, use high basis assets. If it's a charitable gift, use the low basis assets. Because then when the charity turns around and sells that asset to convert the property to liquidity, they're tax exempt, they don't pay any gain. Then the last part is where there are highly appreciated assets, just consider retaining those. Advise your client, look, it makes sense for you to just hold on to this asset. It doesn't make sense to do any planning with it because there's significant gain here, and we don't want to lose the income tax benefit of the step up. And the reason that's important is when you think about where we are in the applicable rates, the income tax rates vis-a-vis the transfer tax rates, when you throw in that net investment income tax of 3.8%, the income tax rate at the highest level surpasses the transfer tax rate. And so it is very important as you're engaging in estate planning to consider the income tax implications of your plan, okay? Don't just focus on the estate and gift tax part, focus on the income tax part as well. Again, though, I want to go back to what I said, dad or mom said, I don't want them to sell that property. Consider that as well. If property is not likely to be sold, then you're not as worried about basis, right? You're only concerned about basis at the time that there's a recognition event. And so keep in mind that as you're going through the plan, talk with your client about what their intentions are for this asset. And we're going to get into a little bit as to like who your client is. I'm a big believer as you put plans in place in engaging the family so that the kids know what mom and dad want. This would be one of those situations where you would want to make sure that the kids understand the intentions. Because if the kids come back and say, Mom, Dad, I love you, I hear you, but as soon as you're gone, we're getting rid of this, then, that's going to obviously impact mom and dad's planning. So it's important to me to have those family conversations. And part of what I do, which I'm really happy I get to do because I'm not billing by the hour when I have these conversations, is I get to have really long, in-depth conversations with clients where they're not concerned about throwing me out because they're looking at their clocks.
Yeah.
Right, exactly. And so, having the opportunity to understand what the family's goals, objectives, and motivations are is really critical in estate planning. And unfortunately, as attorneys, sometimes you're just not afforded that because clients don't want to spend that time with you. But I believe that if there is an opportunity to really do a deep dive into not just what the client wants, or what the client thinks he or she wants, sometimes by spending time and digging deeper in with the family, you really get into what they truly want. So just think about that as well. Any questions? Okay. Then the last thing I want to touch on is, I'm sure many of you are familiar with installment sales to grantor trusts. And those are fantastic wealth transfer. It's a fantastic wealth transfer technique. It's part of it is the beauty and the simplicity of it. Part is that it's blessed by Revenue Ruling 8513. But also when it's maintained and structured properly, the benefits are outstanding. But there may be a reason to consider a taxable sale versus a non-taxable sale. And one reason for that is if that asset that's being sold to the trust, if there is an opportunity or an intent to sell it down the line, by engaging in a taxable sale, there's a step up in basis for that asset by the purchaser. Because when you sell an asset for an installment note, the buyer still gets a cost basis even though payments haven't been made through the delivery of the note. And then as principal is paid on that note, your seller then recognizes gain. There's a couple things to consider. There's 453 Cap A considerations, which is a $5 million limitation. There may be a small surcharge on the note. But again, it goes into the economic analysis of what kind of transaction makes sense. One caveat, though, is if that sale is to a trust set up by your seller or to a family member, the related party rules require that that property be held 2 years before the property is then resold under 453E. So, but it's just something else to think about. Not all what you're used to doing isn't always what makes sense, and sometimes just thinking a little bit out of the box can provide a tremendous result for your client.
Let's talk about a few select planning opportunities. We talked about allowing for flexibility so that when we do have a first spouse to pass, and we don't know what the estate tax laws are currently, we don't know what the assets are currently or going to be, we want to just provide for flexibility. So the next part of this, we're going to be talking about Clayton Trust, Disclaimer Trust, Q-Tip Trust, and a plethora of other opportunities here. Not one fits every scenario. Again, dealing with clients, you have to address their concerns, their objectives, and what we're trying to obtain or achieve in their estate plan. For example, we're going to talk about the mechanics of the Clayton Disclaimer, Q-Tip, Spousal Lifetime Access Trust, and so on. And then we can apply this in certain scenarios of why it would be applicable to one person or one family, but not another. We have our typical Q-Tip trust. Upon death, assets are transferred into a trust for the benefit of the surviving spouse only for the benefit of the surviving spouse. There could be provisions in there that allow for principal distributions based on the ascertainable standard. There could be provisions in there that allow an independent trustee to make distributions of principal for any reason. But upon the death of the surviving spouse, the assets are then distributed to the named individuals that the original spouse wanted. It allows for that control over the subsequent disposition of assets without allowing the spouse to step in and direct their distribution, the surviving spouse. The benefit to the Q-tip is, since upon the surviving spouse's death, the assets are includable in the surviving spouse's estate, his or her estate tax exemption applies. His or her GST exemption can also apply. So you're allowing for that transfer while still having control. With a disclaimer trust states that upon death, I leave assets outright to my spouse or into a marital trust, a Q-tip trust, a 2056B5 trust. But the spouse, the surviving spouse, has the ability to disclaim the interest in the property and allow those assets to pass to a family trust. Now, whether that family trust is for that spouse's benefit plus descendants, just descendants, so on and so forth, that flexibility based on the first spouse's estate is there. The spouse has the ability, the surviving spouse has the ability to direct disposition. Third scenario, Clayton Trust. Clayton Trust, named after Clayton, kind of like Crummy got his success, Clayton got his success in 2018. The Clayton Trust says that upon the death of the first spouse, that spouse directs the personal representative or the trustee to distribute assets to the marital trust, everything, and only the assets that are Q-tip elected by the personal representative, by the trustee, those assets remain in the marital trust, and anything that is not Q-tip elected passes to the credit shelter trust. Sounds a lot like a disclaimer trust, right? The problem here is, or the benefit here is, in a disclaimer trust, if the surviving spouse is insolvent, has a judgment against him or her, has issues regarding creditors, a disclaimer cannot be made because you're attesting to the solvency of yourself to say, I don't need these assets. In a Clayton Trust election, an independent person must make that election. Strike that. Should make that election. The personal representative who is an independent personal representative. That individual is making an election, taking the control of disposition, the decision of disposition, out of the hands of the surviving spouse. Look at the two scenarios with regard to husband and wife come in, prior marriages with separate children. You're giving the ability of this current spouse to make a decision on whether, in a disclaimer trust, to take assets or give it to the prior deceased spouse's children. Could be animosity there, could be angst there, could be tension there. Where in a Clayton scenario, you remove that spouse's ability to make that decision. There are very many commentators that even though the statute doesn't say, or even though the rule is that the spouse can make that decision, it can be considered a gift because you're controlling the disposition of assets if the spouse is making that decision. That's why in your documents with Clayton Trust elections, you have the independent personal representative make the election on what is Q-tippable, and that's made on the 706, or what is not Q-tippable. You're taking it out of the hands. You're making it a more objective standard. So given the scenario with your clients, some of them still like the Q-tip. Some of them are okay with the disclaimer trust. Some of them really appreciate the Clayton Trust because not only is it that misdirection or that direction by an independent party, all of these allow for, other than the Q-tip, all of these allow for flexible planning So what the tax laws are at the time of the death of the first spouse, we can say, let's fund the credit shelter. Let's not fund the credit shelter. You're taking that flexibility to another level. Do you want to talk about spousal lifetime?
Yeah, let's, another planning opportunity involves spousal lifetime access trust, which is commonly called SLATs. And what those are is that's an irrevocable trust, and it's a trust that's created for the benefit of a spouse, spousal lifetime access trust, but also for the benefit of other family members. And these became pretty common around 2012 when there was the $5 million exemption put in place that everybody thought was going to go away and went to sleep December 31st, 2012, having expired, and woke up January 1st, 2013, having come back. But it's a trust that you have a donor spouse take their lifetime exemption amount, or an amount up to that, contribute it to a trust, and the spouse and the children have access to it. Very often it is done by both spouses, because you're utilizing both spouses' lifetime exemptions. So you have husband creates a trust for the benefit of wife and children, and wife creates a trust for the benefit of husband and children, and a red flag immediately should go up that talks about reciprocal trust doctrine, right? Those trusts can't be identical. You need to vary some of the provisions to not trip over the reciprocal trust doctrine. But it allows for the use of the exemption and allocating the GST exemption to it as well. So as a result, none of the assets in those trusts are includable in either spouse's estate. In addition, all of the appreciation in those trusts passes outside of an estate. Distribution made to second generation grandchildren beyond are not subject to GST tax because of allocating the GST exemption. There are a couple of hiccups here, of course, because neither spouse has unfettered access to the assets in his or her trust. Yes, the spouse can be a trustee and can make distributions to him or herself. However, they're subject to the ascertainable standard. And so you would need to have an independent trustee to do anything beyond that. You can give either spouse or give the spouses in tandem the ability to remove and replace trustees, so you limit who has the opportunity to make distributions. But there's a tremendous risk here, and that is if the spouses get divorced, right? So take a situation where you have one spouse who is the moneyed spouse and the other spouse is not, and there's been a gift made of $11.4 million to fully create these slats, and then they get divorced. That spouse gets his or her trust as well as whatever else comes out of the marital settlement. But Joe, how does that compare with a lifetime Q-tip?
Well, the lifetime Q-tip is the same scenario. You cannot put provisions in a lifetime Q-tip that talks about ending the trust upon divorce. In order to receive that marital deduction, you need provisions in there regarding lifetime access.
Right, so what you do there is, in whether you're talking about a lifetime Q-tip or a lifetime Q-tip trust, not so much for a SLAT, because you can't really put a qualified spouse provision in a SLAT. You've given those assets up. But in a lifetime Q-tip, you could say that the spouse only is entitled to receive distributions during such time as he or she is a qualified spouse. And you can put in a term as to what that means, whether it's, cohabitating, or it's the filing of a proceeding, or whatever the legal filing of divorce. You can put in there what a qualified spouse is, and as soon as the spouse does not meet that definition, he or she is no longer entitled to distributions. Okay? Any questions? Okay.
Let's talk about the Qualified Personal Residence Trust, otherwise known as CUPR. They're popular. I've done maybe 15 or 20. I've also unwound, because outside individuals, attorneys that are not familiar with Florida homestead laws, have on many occasions put homestead property, Florida homestead property, into CUPRs. It is not recommended to put the Florida homestead property into CUPR if you want to maintain the homestead exemptions that exist. There is a scenario, and to unwind it or to correct it, let's first talk about what a CUPR is. Qualified Personal Residence Trust is the ability to take an investment property, real property, transfer it into an irrevocable trust where the grantor retains the right to use the property for a term of years. Those term of years are less than the life expectancy of the grantor making the contribution. If the term of years ends prior to the death of the grantor, the asset is then transferred to the beneficiaries in the Qualified Personal Residence Trust, and they become the owners of that property. If the property, if the grantor dies before the term expires in a CUPR, the property value is brought back into the estate of the grantor at the then current value and is taxed in the grantor's estate. The asset still transfers pursuant to the terms of the trust, but the benefit is lost. And the benefit is as follows. Because the grantor retains an interest in the property, called a life interest or a term interest, the gift, which is the remainder portion of it, is a discounted value of the property. We have wonderful programs now, rather than looking through 840 pages to determine what those discounts are. But the life interest discounts the value of the property, which means it discounts the value of the gift. So if $1 million property were being transferred into a Qualified Personal Residence Trust, and the grantor retained an interest for a term of years, that discounted value can be 20%, 25%, 30%, 33%, 40%. Obviously, the longer life or term of years, the greater the discount on the gift. You are transferring asset for a discounted value. With regard to CUPRs, you can have 2 CUPRs at a time, can't have more than 2 CUPRs dealing with more than 2 properties. I've segregated it almost like GRATs in order to do numerous CUPRs but dealing with the same property. Because of the impact of if the grantor dies, you don't get back the gift tax exemption amount that you utilized on your gift tax return. It comes back into your estate and it's lost. So you want to make sure that your grantor survives the term of the CUPR. With regard to homestead property in Florida, because we receive those benefits of the homestead laws, we're the only state, Texas comes close, we're the only state that has such significant protections and exclusions and exemptions. If a homestead in Florida is put into a CUPR, there are a term of years. The way to correct that in order for the grantors to reside in the property and continually maintain the homestead is just before the expiration of the term of years of the CUPR, the trustee and the grantors enter into a 99-year lease. It is recorded, it is for fair value, and in that scenario, the Save Our Homestead laws do not come in and reassess the value of the home. The home is still owned by the beneficiaries, the distribution is still made, but because that lease is in place, the homestead laws are not lost. The exemption, the real estate tax exemptions are still there. All of that must be done prior to the termination. Other non-Florida attorneys don't realize the impact this has, so we talk about and try to correct that when I see it.
The reason we're talking about these is because with this enhanced exemption, I mean, some of these tried and true things just need to be looked at again, right? You can, somebody may have done a CUPR and they may have done it as part of his or her estate plan, But just go back and look. If there's other real property that a client has, just take, you have a second bite of the apple with this double exemption. And that's similar with grantor trusts. As I said earlier, at the end of 2012, there was a ton of planning done at that time. I'm sure anybody that was practicing in doing estate planning in 2012, that December of that year may have been the busiest month of your career. I know it certainly was for me. And as a result, it was because people wanted to make sure that they didn't lose the opportunity for that exemption that was feared to go away. Well, similarly, there's an opportunity to do some of that planning again. And so whether it's just another gift to a grantor trust, it could be the same one. My recommendation is not to make a gift to the same trust. My gift is always to create a new trust and make another gift. Why give the IRS an opportunity to go back and look at a gift that was made in 2012 where you filed a gift tax return, and just leave that trust alone and form another one. But it's just that opportunity to do so. But as I stated earlier, there's always that hesitancy of not wanting, of your client to not want to part with his or her wealth. And that rolls into the next planning opportunity, which is a hybrid domestic asset protection trust. Okay, so I'll get to the hybrid part in a minute, but a domestic asset protection trust, in general terms, is a trust that is set up by the settlor for his or her own benefit so that the assets are not available to his or her creditors. That's not something that's available to a Florida resident. You cannot do this in Florida, so many individuals who engage in that type of planning go to another state like Nevada or Delaware or South Dakota or the many other jurisdictions that do permit this type of planning. It requires engaging a trustee in that state, developing some points, having the trust administered there, but it is something that that many wealthy individuals do to take some money off of the table and put it into a structure where he or she still has access. Again, the problem is if it's not done properly, a court can come in and take it back, right, and say that the jurisdiction of the settlor applies. The hybrid part is where you do domestic asset protection planning where the individual is not an initial beneficiary of the trust, okay? So you set up a trust in, we'll use Nevada for example, and it has all the looks of an asset protection trust except that the settlor is not an initial beneficiary. And a trust protector or another individual that's not the fiduciary for the trust has the ability to add the grantor as a beneficiary of that trust at a time that it may be needed to access those assets. Okay? And so this is a planning opportunity that is starting to gain some steam. And the reason that it is that while the grantor, I'm sorry, I'll use settlor because I go back and forth. While the settlor is not a beneficiary, it is a true third-party trust. So just like any other trust, it's set up for the benefit of the named beneficiaries. At such time as the settlor is added back, you've now exposed those assets to a Huber-type analysis where the law of the settlor may be applied. So one thing to consider then is dividing the trust into more than one trust pursuant to the terms of the document. Most irrevocable trust documents have a division provision in them.
Allow for the trustee to separate trusts.
Right, so it allows the trustee to separate the assets into multiple trusts. All the provisions all the other terms are identical. But what you do is the trust protector then only adds the settlor to the trust that contains the assets that the settlor wants access to. So rather than exposing the entire trust to the claims of a settlor's creditors, you're only exposing or risking exposing those assets in the trust of which the settlor has been added. Okay? So it's a really neat planning tool that should help alleviate some concerns that clients have about giving up those assets irrevocably. There is a way to gain access back if a certain type of trust is implemented. And then we're going to talk about estate planning for qualified opportunity zones, and I just want to throw a quick shout out to our former student, Mr. Ross. Did a great job pitch hitting there, so again, great job with that. So he covered those earlier. And one thing that's interesting is when it gets into doing some planning for those, is understanding the estate tax consequences of an individual who holds a qualified opportunity fund interest at death. The proposed regs that have been issued do not treat death as an inclusion event. And so when an individual holding a fund interest passes, there is no triggering. Rather, it is income in respect of a decedent. Okay? As a result, because there is no trigger event, there is no inclusion, and the interest generates IRD, there's no step up in basis for that asset as well. Okay? As a result, that deferred gain rolls into the hands of the beneficiary. So the beneficiary of a qualified opportunity fund interest steps into the shoes of the decedent. And it's not just for the deferred gain portion. It's also for the 5, 7, and 10-year periods. Those are tacked under the proposed regs. And so if that interest is passed from an individual to the estate, that's not an inclusion event, and then from the estate to an heir, that's also not an inclusion event. So the beneficiary of that interest steps into those shoes, which means that they also are responsible for the deferred tax. Okay? So, for example, you have a senior family member sells an appreciated asset with a fair market value of $2 million and a basis of $500,000 in 2019, rolls that $1.5 million of gain into a qualified opportunity fund, and then senior dies 2 years later, leaving that interest to the child at a time that the interest is worth $2.5 million. It's valued for estate tax purposes of $2.5 million. It's reduced by the $1.5 million, which is the gain rollover, and the child steps into the shoes of the senior family member with respect to that interest. So they get that benefit of that 2-year holding period as well. Okay? So in the event of a passing of an interest at death by reason of death, the beneficiary of that heir steps into the shoes of the original owner. Gift tax consequences are a little different. So if there's a gift made of an interest, that is an inclusion event. You've transferred it from one taxpayer to the other voluntarily, so the proposed regs do treat that as an inclusion event. However, if it is a gift to a grantor trust, that is not an inclusion event. And think about the reason for that. We talked about it earlier on an installment sale transaction, right? That Revenue Ruling 8513 applies here as well. And so the transfer of a qualified opportunity fund interest from an individual to a grantor trust is not an inclusion event. Similarly, when the grantor dies, the termination of the trust, of the grantor trust status by reason of death is also not an inclusion event. Termination for other reasons is. So if you have a client that just says, look, I don't want to pay the tax on this, let's terminate grantor trust status, that's a trigger event, okay? But if it's by reason of the grantor's death, it is not. Again, think about the grantor trust rules as we're talking about this. When there's a transfer made to a trust, the grantor is still responsible for all the tax items. For income tax purposes, no transfer took place, and these are income tax rules. So they apply here as well. There's not some special carve-out for a qualified opportunity zone that's a qualified opportunity fund interest that is held by a grantor trust. Okay? And so in this instance, if you have a transfer to a trust and you have a again, they step in the shoes, you have the tax holding period and everything else. But one thing that you need to think about also is that when you make a gift, you have 2036 issues, right? There still may be an issue, there may be some strings that the IRS seeks to apply to bring the value of the fund back into senior's estate. And so consider selling the qualified opportunity fund interest to the trust in exchange for an installment note, just like any other installment sale transaction. If you do that, then just what we talked about before, the gain is deferred as if senior owned it him or herself. The 10-year period applies as if the individual owned it him or herself. And so when you think about the purposes of an installment sale to a grantor trust, a qualified opportunity fund interest just fits perfectly into what you're trying to accomplish. Because let's say that your senior family member survives the entire 10-year period, okay? You have the senior family member picking up the capital gains on the 85%. Remember, 10% is forgiven after 10 years, another 5% after 7 years. After 10 years, assuming that we don't get to 2026, of course, and nothing's changed, you have a senior family member who pays the tax. Well, one of the benefits of a grantor trust is that the senior family member does pay the tax. It's an estate depletion technique. And if this property triples in value over the 10 years, all of that gain, all of that appreciation is outside the estate, and the capper of it, which is better than even in a regular installment sale to a grantor trust, is that the trust gets a stepped-up basis, right? One of the problems with transactions involving grantor trusts is that there's no recognition event that causes a step-up. Well, here, under the qualified opportunity zone rules, if the trust owns the property through the 10-year period, at the time it is sold, the basis is deemed to be the fair market value at the time of sale. And so when you're thinking about a client who is engaging in these types of transactions, talk to them about doing some estate planning with it. Because it is, as much as I enjoy a normal installment sale to a grantor trust transaction and have seen the benefits that it can provide for clients, the benefits that these qualified opportunity funds provide really is well, it's pretty amazing for clients that can afford to do it.
Well, look at it. You get a step-up basis, cost basis, no income tax consequences, and you get to transfer the exposure and the benefits that the senior family member had to a junior family member.
Right. And
You
so,
don't get those in any other aspect of the law other than under this opportunity zone because it's written into the code.
that's right. And so, a lot of this is still being fleshed out through the proposed regulations. And so just keep an eye on that. But if you do have clients who are engaged in these types of transactions for their own investment purposes, it's something to consider for their estate planning purposes as well.
We've got a few minutes left, and we've got to talk about these ethical considerations in meeting with an estate plan. Now, meeting with estate planning clients.
And to be clear, this has nothing to do with the Tax Cuts and Jobs Act.
Correct.
We needed to discuss some ethics issues to make sure that the ethics credit was provided, and so here we go.
Here we go. Always need to address who is your client, who's walking in the door. A senior family member, junior family member, talking about a senior family member, an individual that has a power of attorney over an individual, husband and wife, or a family. I can tell you with regard to practicing, and Bob, I'm sure you're very clear on this as well, you have to specifically identify who your client is and let everyone else know if the family is going to be involved, who you represent. It is difficult to represent the family. It is easy to represent senior family member. It may be okay to represent husband and wife. It may not be okay to represent husband and wife and junior family members. So with regard to your representation, identifying who your client is, making that specific, and then addressing that issue with anyone you will meet as a result of that representation is key in ensuring that the first question you don't get when somebody has an issue, well, I thought you represented my interest. Responsibility to beneficiaries and fiduciaries. If senior family member walks in and there is an estate plan put in place where there's wealth preservation opportunities, family entities set up, your relationship and your goal and your priority is the senior family member. If you do not represent the beneficiary. You do not represent the fiduciary unless the senior family member is the fiduciary. You have to segregate your roles. You need to address the beneficiaries by saying you may want to go retain counsel for that. Bob, I know in your prior practices, you dealt a lot with family wealth preservation, family wealth entities. Senior family members and junior family members were not always on the same track.
No, that's true. So when I was practicing, obviously I did a lot of work with families. I did quite a bit of intergenerational wealth planning. And, when mom and dad walk in, their intent is always to maintain family harmony, or at least maintain whatever family harmony is is in place at the time that they come to see you. But as plans develop, you run into situations where who you represent does become a little murky, because you're creating entities. You're creating trusts that have fiduciaries and beneficiaries. And in a strict reading of the rules, each of those parties needs his or her own separate representation, because they're pretty much adverse to one another at each step. I would posit to say that if you really want to understand one's personality, share an inheritance with them. You'll see their true colors really come out. And I did have a case, and I think all attorneys tell stories. I'll just tell one here. Mom and dad walked in. They had a business. They were both shareholders in the family business. Son worked in the business. The other son and daughter did not, but they wanted to do planning, and they wanted to treat all their kids equally. And so they put an estate plan in place that divided assets. We actually did an installment sale to a grantor trust. And as a result of that transaction, each child had a trust that was, it was a separate trust, 1/3 of the assets for each. Unfortunately, a year after we did the transaction, dad died. And a couple of years later, son sold the company. It wasn't against anyone's wishes. Frankly, he had an offer he couldn't refuse, and a company that was valued at $175 million at the time of dad's death actually was purchased for $600 million. And so, as a result, each trust had $200 million in it for the benefit of these kids. Everything was fine until one of the children decided that he was not going to have children of his own, okay? And the way the trust read is that the trust was for child and descendants. And if the child had no descendants, that then the beneficiaries were descendants of mom and dad. And so son, who was an entrepreneur, he was the one that was in the business, wanted to utilize these assets the way he wanted to use them. It was for his benefit. He wasn't going to have kids. Who was going to get harmed? Sister was going to get harmed. And she made it clear that she was going to get harmed. And she made it clear that the money was there for her children. Oh, and by the way, she said it wasn't about the money. It was about the principle of it. It's always about the money. And so she had her own trust for $200 million. What can I tell you? At that point, we had been working with the family. And you can't anymore. They are clearly adverse. And so we had to have some difficult conversations, because who are we going to represent? Was daughter going to allow us to continue to represent her brother, whom we were representing not just with respect to this trust, but with respect to his other business activities? We had a real issue. And so it was an issue that had to be negotiated. And there were documents that had to be drafted to ensure that daughter was satisfied. And sometimes you also have to get a little creative and, take assets out of a trust and put them into a single member LLC where the trust doesn't govern what happens, rather the LLC does. But that's a conversation for another time. But you have to understand what the issues are, not just when a plan is being structured and when it's implemented, but when it's being maintained, because the landscape can shift underneath the attorney's feet during those different stages.
Any questions?
Last thing I'll add, and just again, with respect to the engagement of professional advisors, anybody that works in this area, please note that anytime you engage an advisor on behalf of a client, that the attorney should engage the advisor utilizing a Covell letter, so that the work product of this professional that's engaged is protected, but that the client, not you, is responsible for paying the bill. So that's it. Are there any questions about anything we talked about? All right. Well, we got you out here an hour late, so we did our job.